Welcome to this introduction to the Equality Act 2010. In this presentation, we'll share the basics of the Equality Act 2010, what it covers, who does it protect, and what it does and does not do.
We'll look at what the 9 protected characteristics are,
and how they can be applied through prohibited conduct, that is, discrimination, harassment and victimisation, as well as positive action, a permitted approach to improving equality in the workplace. And when we meet in person, we'll do some scenario-based activities to help embed this new learning.
But first, let's take a quick look at the history of the Equality Act. So the Equality Act 2010 consolidates 116 separate pieces of legislation that already existed. The Act applies to employees, although how an employee is defined in the Equality Act is broader than other legislation and covers some freelancers, zero-hour contract workers, and other atypical workers. The Act provides a legal framework to protect the rights of individuals and advance equality of opportunity for all. It provides Britain with a discrimination law which protects individuals from unfair treatment and promotes a fair and more equal society. There's no qualification period. An individual can bring a claim from their first day in employment or earlier if challenging discrimination in recruitment.
The 9 pieces of legislation that were merged to form the Act are the Equal Pay Act of 1970, the Sex Discrimination Act of 1975, the Race Relations Act of 1976, the Disability Discrimination Act of 1995, the Employment Equality Regulations for Sexual Orientation and Religion or Belief in 2003, Age in 2006, and updates to the regulations on sexual orientation in 2007, and the Equality Act Part 2 in 2006. So there are 9 protected characteristics which you can see represented in the previous legislations that were merged. These are age, disability, gender reassignment, marriage or civil partnership, pregnancy or maternity, sex, sexual orientation, race, and religion or belief. So let's take a look at these in detail.
Age. The Equality Act 2010 says that you must not be discriminated against because you are or are not a certain age or in a certain age group. Someone thinks you are or are not a specific age or in an age group. This is known as discrimination by perception. Or you are connected to someone of a specific age or age group, and this is known as discrimination by association. Age groups can be quite wide, for example, people under 50 or under 18s, and they can also be quite specific, for example, people in the mid-40s. Terms such as young person and youthful, or elderly and pensioner can also indicate an age group. There are exceptions here where it can be legal if being of a certain age is an occupational requirement. So, for example, if you were hiring a child actor to play a specific age, or being over 16 to serve alcohol.
disability.
The Act says someone is disabled if both of these criteria apply. 1, they have a physical or mental impairment, and 2, the impairment has a substantial and long-term adverse effect on their ability to carry out normal day-to-day activities. A small number of conditions and impairments are automatically classed as a disability, for example, cancer, HIV, and MS. Substantial means that the effect of your condition or impairment has on your ability to do day-to-day things must be more than minor. For example, if you have a relatively minor hearing loss or visual impairment that can be corrected with glasses, then you're unlikely to meet the definition of disability in the Equality Act. A long-term effect is defined as one that has lasted or is likely to last for at least 12 months or for the rest of your life. If your condition or impairment has had a substantial adverse effect on your ability to carry out day-to-day activities, but that effect has stopped, the Equality Act still covers you if it's likely to reoccur. Nobody has to tell their employer or potential employer that they are disabled. Employees are still protected from discrimination if their employer could reasonably expect to know if they have a disability. Employers have a responsibility to make sure that disabled people can access jobs, education and services as easily as non-disabled people. This is known as the duty to make reasonable adjustments. Disabled people can experience discrimination if the employer doesn't make a reasonable adjustment, and this is known as a failure to make reasonable adjustments. Reasonable adjustments are basically changes an employer can make to remove or reduce a disadvantage that is related to someone's impairment. So what is reasonable depends on each situation. The employer must consider carefully if the adjustment will remove or reduce the disadvantage, so the employer should talk with the person and not make assumptions. If the adjustment is practical to make, is affordable, or whether it could harm the health and safety of others.
Gender reassignment. So gender reassignment means proposing to undergo, undergoing, or having undergone a process to reassign your sex. To be protected from gender reassignment discrimination, you do not need to have undergone any medical treatment or surgery. You can be at any stage in the transition process, from proposing to reassign your sex, undergoing a process of reassignment, or having completed it. It could be something like using new pronouns or changing your name. You don't need a gender recognition certificate, which is the document that confirms the change of a person's legal sex, to be protected. And depending on the circumstances, the law on gender reassignment discrimination might protect non-binary people, who are people who don't see themselves as exclusively male or female. And it also may protect people with variations in sex characteristics. Some people use the terms differences in sex development or intersex. There are some specific circumstances where it's lawful to treat a trans person differently, and these are known as single-sex exemptions. So a service provider who provides single-sex services, the Equality Act allows for separate or single-sex service providers to prevent, limit, or modify people's access on the basis of gender reassignment in some circumstances. Limiting or excluding a trans person from separate or single-sex service of the gender in which they present will be unlawful if you cannot show such action is a proportionate means of achieving a legitimate aim. And this applies whether or not the person has a gender recognition certificate.
Marriage or civil partnership. Marriage is a formal union legally recognised in England, Scotland and Wales as a marriage. Civil partnership is a partnership registered under the Civil Partnership Act 2004. Marriages and civil partnerships can be between people of the opposite sex or people of the same sex. By law, if you're married or in a civil partnership, you are protected even when not living together.
Pregnancy and maternity discrimination. So pregnancy is the condition of being pregnant or expecting a baby, and maternity refers to the period after the birth and is linked to maternity leave in the employment context. In the non-work context, protection against maternity discrimination is for 26 weeks after giving birth, and this period of time is called the protected period. And this part of the legislation also includes treating a woman or a person unfavourably because they are breastfeeding.
Sex discrimination. This is when you are treated differently because of your sex. In the Equality Act, sex is understood as binary, being either male or female. There has been a recent Supreme Court decision in For Women Scotland Limited versus the Scottish Ministers for Women Scotland, where the UK Supreme Court has ruled that the definition of sex in the Equality Act 2010 should be interpreted as biological sex only. For the purposes of the Equality Act 2010, a person's legal sex is the one that was recorded at their birth. This changes the previous interpretation adopted by the courts, which was the definition of sex also including people who have obtained a gender recognition certificate, and according to the Supreme Court decision, obtaining a GRC does not change your legal sex for Equality Act purposes.
Sexual orientation. The Equality Act defines sexual orientation as a person's sexual orientation towards people of the same sex, people of the opposite sex, or people of either sex. So this means being gay, lesbian, heterosexual, or bisexual. And it's important to note that the law might not reflect the language people now use to describe their sexuality. People with other sexual orientations might still be protected by discrimination law. This could be if they experience less favourable treatment because of their sexual orientation.
Race. In the Equality Act, race can mean colour, so this refers to a person's skin pigmentation, nationality, including a person's citizenship, and ethnic or national origins, which might not be the same as a person's current nationality. It also includes racial groups. So this refers to a group of people who share a protected characteristic of ethnicity or race. For example, Black Britons, British Asian, British Sikhs, British Jews, Romani Gypsies, and Irish travellers are all considered racial groups.
Religion or belief. So you're protected from discrimination because of your religion or belief. If you belong to an organised religion such as Christianity, Judaism or Islam, have a profound belief which affects your way of life or view of the world, and this includes religious and philosophical beliefs, or no beliefs, a lack of beliefs such as atheism. If you take part in collective worship, or if you belong to a smaller religion or sect, such as Scientology or Rastafarianism. It's important to note that the law against discrimination because of religion or belief does not cover purely political beliefs unless they are also philosophical beliefs. The Equality Act also says that a belief must be worthy of respect in a democratic society and not affect other people's fundamental rights. So let's look at how this can be applied. There are 4 types of prohibited conduct, and these are direct discrimination, indirect discrimination, harassment, and victimization. Positive action is a practice that is permitted and can contribute to more equal practice.
There are 3 forms of direct discrimination. Direct discrimination against someone who has a protected characteristic. This is when someone is put at a disadvantage and treated less favourably because of a protected characteristic they have. Discrimination by association. This means discriminating against someone because of their connection with either someone who has a protected characteristic, for example, a family member, friend, or colleague, or a group of people who have a protected characteristic. And finally, discrimination by perception. This means discriminating against someone because of a perceived protected characteristic.
Indirect discrimination is when a working practice, policy, or rule is the same for everyone but has a worse effect on someone because of a protected characteristic. Indirect discrimination can be less obvious than direct discrimination. It might not always be someone's intention to discriminate. So the policy, rule, or practice would put people who share a protected characteristic at a disadvantage. It puts someone personally at a disadvantage, and the employer cannot justify the course of action. So they're the conditions that you need to meet for it to be considered indirect discrimination. And the term share a protected characteristic does not always mean everyone with a characteristic. So, for example, it could mean people with a particular disability. For example, anyone with an equivalent level of visual impairment, not all disabled people as a whole, or people of the same age or age group, or people who share an aspect of race, for example, all Southeast Asian people. So some examples of working practices, policy and rules can include things like formal and informal policies, decisions about ways of working, and they don't always need to be written down. The legal phase is provision, criterion, or practice. And examples of that are decisions around workplace facilities, for example, toilets, rest areas and canteens, dress codes, or policies and ways of working for example, flexible working or working from home.
Harassment is defined as an unwanted behaviour related to a protected characteristic. This type of harassment is unwanted behaviour related to all of the protected characteristics apart from marriage and civil partnership and pregnancy and maternity. To be harassment, the unwanted behaviour must have either violated the person's dignity or created an intimidating, hostile, degrading, humiliating, or offensive environment. It can be harassment if the behaviour was not intended to have this effect, or was intended to have the effects but didn't. By law, whether someone's behaviour counts as harassment depends on the circumstances of the situation, how the person receiving the unwanted behaviour views it, and if the person receiving the behaviour is reasonable to view it as they do. So what is unwanted behaviour? Unwanted behaviour can include a serious one-off incident, repeated behaviour, spoken or written words, imagery, graffiti, gestures, mimicry, jokes, pranks, physical behaviour that affects the person. Sexual harassment is a form of harassment and is an unwanted behaviour of a sexual nature. This type of harassment does not need to be related to a protected characteristic. For example, someone who thinks they've been sexually harassed does not need to show if it was because of their sex or sexual orientation. Less favourable treatment is a result of harassment. So this type of harassment is when someone experiences less favourable treatment because of how they respond to previous harassment, and it can apply whether the person rejected or accepted the previous harassment. Harassment happens when the person is treated less favourably than they would have been if they had not responded to the previous harassment in the way they did, and the previous harassment must either have been sexual harassment, harassment related to sex, and harassment related to gender reassignment.
Victimization. Victimization is treating someone badly because they've done a protected act, or because an employer, service provider, or other organisation believes that you have done or are going to do a protected act. The reason for the treatment does not need to be linked to a protected characteristic. A protected act is making a claim or complaint of discrimination, helping someone else to make a claim by giving evidence or information, making an allegation that you or someone else has breached the Equality Act, or doing anything else in connection with the Equality Act.
Positive action. Positive action is designed to address existing inequalities and imbalances faced by certain groups who share protected characteristics. Positive action is lawful under the Equality Act 2010, provided it is proportionate and doesn't amount to discrimination. It does need to be evidence that there is a need for it and that the action being taken is proportionate. So positive action is about taking specific steps to improve equality in the workplace. It can be used to meet a group's particular needs, lessen a disadvantage they might experience, or increase their participation in a particular activity. You must be able to show that positive action is an appropriate way for your organisation to achieve one of these aims, and the steps you are taking have been carefully thought through. Using positive action at work is voluntary. Employers who use positive action measures may find it brings benefits to their organisation, including a wider pool of talented, skilled and experienced people from which to recruit.
So what the Equality Act doesn't do. So the Equality Act tells us what not to do, but it doesn't tell us how to create an inclusive culture. We think of inclusion as a systematic strategy to ensure everyone shares the same advantages and benefits, and that would include everyone being able to perform, everyone can belong, and everyone can reach their potential. So complying with the Equality Act doesn't automatically mean everyone can perform, everyone can belong, or everyone can reach their full potential. As you can see on the slide, inclusion only appears 4 times in the Equality Act. Diversity appears 5 times. It's not intended to build a culture, it's intended to prevent discrimination. So we can be legally compliant with the Equality Act and still not have an inclusive workplace. And it's always important to remember the Equality Act tells us what not to do. Inclusion is what we choose to do.
So, in this video, we've learned about how the Equality Act was formed, what came before it. We now know what the 9 protected characteristics covered by the Act are, and the different types of direct and indirect discrimination, harassment, and victimisation. We've also learned about positive action. So thank you for watching this video. If you do have any questions or comments, please keep a note of these and we can go through them when we meet in person. Thanks for watching.
Thank you.